enforced by the Federal Trade Commission. It's enforced by the Federal Trade Commission, so keep that in mind. We've seen that question show up on some tests too, so you should be aware of that. Now, Congress passed many years ago now the Real Estate Settlement Procedures Act, or we refer to that, of course, as RESPA. RESPA applies to all federally related 1 to 4 family residential mortgage loans. Now let's look at that a little bit. Federally related. How do we define federally related? Virtually any loan, mortgage loan, is going to be defined as federally regulated. If it goes to FHA, if it goes to VA, if the proceeds come out of a nationally regulated bank, if it's loans being sold to Fannie Mae, Freddie Mac, all of those are federally related. I think the one obvious exception is if I do owner financing. I'm not federally related, so I wouldn't fall under RESPA. But to err on the safe side, virtually all loans are going to fall under RESPA. And it applies to 1 to 4 family. So it applies up to a 4-plex. It doesn't apply to a 5-plex, 6-plex, or an apartment complex. It's just that 1 to 4 family. Now, what are RESPA's rules? What does it say? Well, first off, it requires some disclosures. And you want to remember all 3 of them for test purposes. It requires that the lender provides the borrower with a special information booklet. And that information booklet has to do with closing costs, and it explains to the borrower just what kind of fees he's paying in regards to this particular loan. Secondly, the lender has to provide a good faith estimate. Or you could abbreviate that GFE. I guess I pronounced GFE GUFA, or however you want to pronounce it. That's a good faith estimate, and that lists what are the closing costs, potential closing costs are going to be, and how much the monthly payment is going to be. Thirdly, the lender has to provide a mortgage servicing, I could drop to the next line here, disclosure statement. And what this mortgage servicing disclosure statement tells the borrower is the likelihood of his loan being sold. I know some lenders I work with, they will give me the mortgage servicing disclosure statement and it says they never sell their loans. And other lenders will say that they sell 90% of their loans or they sell 100% of their loans. But by federal law, under RESPA, the borrower has to be notified as to what is going to happen to his loan or potentially happen to his loan in the near future. Now, all 3 of these have to be provided at the time of loan application or within 3 business days. You should know that at the time of loan application or within 3 business days. And that's something you need to commit to memory because we have seen test questions on that. Now, RESPA also does this. It prohibits kickbacks and fee splitting. For example, I'm not a mortgage loan officer, but say that I send one of my buyers to my favorite mortgage loan officer, and every time I do that, he sends me a check for $500. That's a violation of RESPA. You can't do that. That's a kickback. Or he can't split the origination fee with me. That's fee splitting. That's a kickback. And you really can't work around this either. I was familiar with one company, and they knew about RESPA. They had an in-house mortgage officer, and they provided him space within their real estate office, and they knew that when they provided him clients, he couldn't pay them money directly. So they got a little bit creative. He was working out of about a 12 by 14 cubicle, and they were charging something like $5,000 a month rent for that. Well, of course, he was coming out on the good side because he was getting all the borrowers, all the buyers out of that particular office. But that's a violation of RESPA. You can't do that. There is no fee splitting or kickbacks allowed. In addition, you cannot be compensated, overly compensated, for doing something in the transaction. I'll go back to my first example. Say that I'm a loan officer. I'm licensed as a loan officer, and I'm working with a mortgage broker. So I'm also working as a real estate salesperson. So I go out and I find a buyer, and I take him to the mortgage broker to get financed. And the mortgage broker says, well, Tom, you fill out the application. So I just fill out the application, and it takes me maybe an hour, something like that. And in return for that, the mortgage broker gives me $1,000. Well, that's way above industry standards for that act. Maybe it was worth $100 or $200. That is also a violation of RESPA. You can't do that. So if you see questions like along those lines, be aware and have an understanding of what fee splitting is and what kickbacks are involved. Now, in addition, RESPA also requires the use of the HUD-1. The HUD-1, many of you maybe would be familiar with. It's about the last of the legal size forms we use in the real estate transaction. The HUD-1 lists all the seller's expenses, lists all the buyer's expenses. It lists the entire financial information of that transaction. And a good rule of thumb is this: if you can't put it on the HUD-1, you shouldn't be doing it, because it's going to be a violation of RESPA or some other law, no doubt. So your entire transaction should be able to be placed on the HUD-1, all the cost, who's getting what paid, who's paying what, and the HUD-1 is going to be a summary of that. Now, the borrower is entitled to receive that HUD-1 one business day prior to closing. Now, a lot of times, of course, you're only going to get that HUD-1 about, I had a closing a couple weeks ago. I got it 5 minutes before the closing occurred. The borrower could have demanded and said, Tom, I want to look at this for 24 hours, because he's entitled to receive it at least one business day prior to closing. Now, who makes sure that that HUD-1 is correct? Who has the responsibility of that? And you may say, well, the attorney prepared it or the title company had prepared it. That's not true. What the law says is that you have a responsibility. I have a responsibility for that. The agents involved in that transaction are jointly and severally liable for the accuracy of that HUD-1. So you better understand the HUD-1 and be able to explain it to your buyer and know if it's correct or not, or explain it to your seller. I like to get it a day before I go through that HUD-1, make sure everything is correct on that, because I know I have a liability there. But if you ask that question, it's you and I that have the liability on that. Now, the law also has the Equal Credit Opportunity Act. Now, the Equal Credit Opportunity Act came about, and again, I don't remember the date off the top of my head, date's not important. It came about to prohibit discrimination in granting mortgage loans. The Equal Credit Opportunity Act covers this group of individuals, and it prevents discrimination by the lenders based on color, race, religion, national origin, sex, marital status, age, and persons receiving income from public assistance. Now, one of the confusions that you'll see when you're taking a test on this is the test makers will try to confuse you between the Equal Credit Opportunity Act and the Fair Housing Act. And my suggestion to you is this, is you learn the protected classes under fair housing: race, color, religion, sex, national origin, handicapped, and familial status. There's 7 classes there. Notice that I did not say age, which is protected under ECOA. I did not say marital status, which is protected under the Equal Credit Opportunity Act, or we call that ECOA. So if you know the Fair Housing Act, then you're not going to get confused on this. I'll tell you an interesting story about the persons receiving income from public assistance. You may say, well, that's a strange, what does that have to do with anything? Well, years ago, I sold a house. Well, let me backtrack a little bit. I was sitting in a restaurant. I'd recently received my real estate license, and I was obviously looking for clients, customers. And I was sitting in a restaurant. In the booth next to me, there was a young lady and her parents, and they were talking about her buying a piece of real estate, or buying her own home. And so my ears kind of lit up, and being the brazen young man that I was, I walked around to their booth and said, "Hi, my name is Tom Jensen. Here's my business card. I couldn't help but overhearing that you want to buy a house. How can I help you?" Well, for some reason that approach worked, and they said, well, sit down and let's talk about it. And I said, man, I got a client here. I'm in good shape. And so I started talking to the young lady, and I said, well, what do you do for a living? She says, well, I don't work. Okay. Well, do you have a down payment? She says, no, I don't have any money. And I says, you want to buy a house? Oh, yeah, I want to buy a house. Well, we got two problems here. We got to solve these problems. First off, I said, why don't you work? You look fine to me. I didn't put it that way, but I was thinking that, okay? Why aren't you working? She told me this story. She said this. She said, I was living in a house, and at one time I was married. This is the garage here, okay? And she said, I had a master bedroom in my house. And the bed was right here. Okay? She said, one night, during the day when I wasn't around, my husband, who's now my ex-husband, was fooling around in the garage. That's a car. I know, it doesn't look like a car. And she said, my husband did this. He took the garden hose and he duct taped it to the exhaust of the car and then drilled a hole in the wall underneath the master bedroom bed and ran the hose in underneath the bed. She said he got up about 2 o'clock in the morning. He went out and started the car, and then he walked down the street to have a cigarette, and in the meantime, carbon monoxide was flowing into the bedroom. It just about killed her. Now, what it did do, it caused severe liver damage. So when I met her, she was recovering from that, but she had severe liver damage, and if you know anyone that has liver damage, they can't stay awake very long. They're good for about an hour, then they've got to go to sleep.